You know, the problem I'm having is that you seem to be equating report with a form. And my problem is that as I read everything in the statute, the report, you say it's not as to an account, and Justice Jackson says not to an account either. But the whole structure says every time you make a transaction or maintain a relationship for any person with a foreign financial agency, you have to tell the government about that. That's what the word report means. Whether you do it on one form or 10 forms is irrelevant to me. I think the essence, as set forth in the plain language of the statute, is if you have a relationship, an account, tell me about it. That's what the government, I thought that was the whole purpose of this act, was that wealthy people were squirreling away millions of dollars in foreign accounts all over the world. And the government wanted to know where these accounts were. That's the whole purpose of the statute. All of the transactions that are being set are in the singular. In the case of a violation involving a failure to report the existence of an account. I'm taking out things that are irrelevant. The amount of the penalty is the balance in that account. So to me, where am I missing your argument?
So
you seem to be equating report with a form. I'm equating report with what the statute talks about, the transaction, the account.
A few points, Your Honor. First, what the statute actually says, the only thing that is imposed on the regulated party is to file reports. Now, file, I think there is a very important verb. That is a formal submission. You're taking a report and you are filing it. Now, the only reference to accounts is in that triggering conditional language. And again, it does not say that you need to report each account. That's not the statutory language. The statute defines when the secretary, and again, this is directed ultimately to the secretary. Secretary, you figure out what reporting requirements are necessary. And then the regulated party has to file reports as the secretary requires. The secretary could say, I'm not going to have reporting requirements at all. I'm just going to have record-keeping requirements. It's entirely up to the secretary how to frame this. But the violation is of the statute, and the only statutory duty is to file reports. And I think this is especially clear going back to the original version of the Act, which is framed in terms of who needs to file reports. It's identifying the class that the secretary is supposed to regulate. That who clause in the original version is the only reference to specific accounts or specific transactions. And again, the targeted conduct is filing reports. Now, as for the part about Congress trying to prevent people from doing bad things with foreign accounts and doing money laundering and tax evasion, Congress originally was focused on the willful violator, which is why for decades under the Act, there was no penalty whatsoever for a non-willful violation. So it'd be pretty extraordinary in 2004 if Congress went after decades of no penalty to suddenly millions and millions of dollars for failing to file, again, non-willfully, a single report that happened to list multiple accounts. So I hope I'm answering Your Honor's question.
I'm not sure, but that's okay.